Exclu- exclusive river legal right of property. Type of property: tangible, corporal, and intangible incorporeal. Development of ownership. So, originated with settled life. First developed in Roman law, dominium absolute right. Developed later in English law, presumed from possession. Ancient origin in India have Roman law influence. Then the type of ownership. So, there is absolute, limited, corporal, incorporeal, sole, co-ownership, vested, contingent, legal, equitable, and trust ownership. Views of jurists. Einstein. Relationship between person and thing. Right, indefinite, unrestricted, and unlimited. Criticism. Bundle of rights restricted by state and limited duration is there. And the Salmon say relationship between personal and right, exclusive exercise of right, definition of incorporeal ownership include possession, use, enjoyment, disposition, and maintenance, and residual power, and criticize the incomparable ownership is complex. Ownership over think, not right, and complete control is accepted. Then the Holland, what the Holland say, four kind of rights: right to use, exclude, dispose, and destroy. And then Hilbert says four kind of right: use, exclude, dispose, and alienate. Then comes the Renner says the Marxist view capital over others should be public view. Emphasis on public and private ownership. Then comes the characteristic of ownership. So the it is absolute or restricted. Tax and duty obligation is there, and connect cause harm, illegal disposition no doubt, and transfer of successor is there, and not compound on incest and minor. Then comes the second chapter, the possession. So possession is defined as the intentionally established physical control obtained by will, intention, and physical control. So Salmon definition. So continuing exercise of exclusive use claim and element of possession. So mental element, animus possidendi, will and intention, and physical element, corpus possidendi, physical control. Then comes the method of acquiring possession. So, by assuming or taking without owner consent, by gradual delivery with owner consent, and by enforcing the law, the legal transfer. The characteristic of possessions are the physical control and intention is necessary. Primary facia evidence of abundance is physical control and intention. 9/10 of ownership principle, and challenger must prove better claim and exclusion of others necessary. Then come the type of positions. So there are several types: corporal, incorporeal, immediate, mediate, factual, de facto, and legal, de jure, and constructive, indicative, indirect, and concurrent encroachment. Then the similarities between ownership and possession. So right provided use, consumption, and disposition, and transfer required physical control and dissimilarity or difference. So the this ownership is legal, whereas the possession may be legal or illegal. The ownership is legal de jure and the possession is de facto, the factual. The ownership have legal title necessary, but the possession have intention or physical control. The ownership have physical control, duration independent, but the possession have dependent. The ownership legal process for transfer and owner possession have no formalities, and ownership always rightful, and the possession can be wrongful or illegal. The ownership includes right to possess, but the possession does not include right to ownership or the ownership. So protection of possession. So why? Prima facie evidence, difficulty in proving ownership immediately, adverse possession for 20 years. Then comes the second topic, what is the factual relation concept of law? So rights, liabilities, duties, personality, contemporary legal issue, crime against women and children, and law land in Rajasthan are discussed in future lectures.